Hello. Happy weekend. Hello. Well, Sunday. Happy Sunday, fun day. Hello. I see a bunch of my mods in here. Shout out to all the mods. Hello, my loves. Okay, wait. If Nightbot starts going rogue, let me know. Let's see. Hello. Happy Sunday. I hope you guys have all had a lovely weekend thus far. I definitely had. I planned to go live yesterday and I was like, I need a break. I need some time to really dive deep into a few cases I've been talking about and one new one that I hopefully will go live on tomorrow. If not, maybe Tuesday. I'm so excited. I hope you guys can make it to this one. I'm not going to tell you who it is. You'll just have to wait. So yeah, I spent all day deep diving. Don't worry if I'm not here, still doing true crime. Hello, Debbie. Hello, Patty. Hello, Chief. Hello, everyone. Hello, my beautiful Augie. Hello, Femme. Dodge. Good to see you. Domestic Pinup. Hello. The Rogue. Hello. Yeah, don't let it scroll out. I know. We're probably going to do, I have a couple lives planned today. Hello, welcome. My name is Melly. We're going to be covering, I always forget there's like new viewers. Hello, new subbies. Hello, new viewers. All of the above. Hello, thank you for being here. We're going to be covering Kohberger motion to delay trial today. We are document nerds here, so we have a lot of fun, but we do like to get serious and read some documents, right? That's supposed to be a wink, but we're going to cover the Bryan Kohberger document. I do have Karen Reed live marathon planned tonight. I do have another live after this. We're going to do a quick update on Courtney Clenny, and then I have deep dived a case I'm really excited to talk about tomorrow. I might give you guys a little clue. I'm really, really excited, and I really did put a lot of time into it. So we got a lot of true crime, a lot of things going on. I'm going to read this document. 40 pages sounds like a lot, but not when you're here. I read really fast. We get through it. It's a good time. So thank you for being here. Make sure you hit the like button, subscribe, do all the YouTube thingies. This is a vertical. We've been doing the verticals. I really do like them. But we might go back OG tonight. We might take it back for one of the other lives. So I'm going to pull up the document. I'm excited to, yeah, it's like one day I don't go live and then I want to come here and go live like all night. It's really, yeah, it's really a lot, but I enjoy it. So thank you for being here. All right, enough of me chit-chatting away. Let's get started. Oh, thanks, Fem. Thank you. I tried to be. So motion to continue Bryan Kohberger. Before I get started, this was filed on May 20th, so 5 days ago. Motion to delay the trial. Basically, I have not watched the Dateline episode. I'm going to watch it tonight or tomorrow, so don't tell me what happens, but a lot of what was put into that Dateline episode is now creating a problem with the case and the trial, and they're asking for a delay because things got out, things were said, and I feel like as much as we want to know everything as true crime junkies, like I do feel like those things obviously do cause a commotion, right? And so not that I'm on the defensive side, but I do feel like anything that they can try to continue to put out on this trial, hold off and make Bryan look good. They're going to get every chance they get. They're going to do it. Right. And so, I'm just kind of bummed out. I hope that this it's going to delay the trial. I don't know. Let me know what you think, because, it is a new judge. Judge Hippler is really, really, on it. So I'm thinking, a part of me thinks like maybe he won't let them delay it, won't choose to delay it. And then I think he might, things leaked out and he needs to look into it and get, whatever's going to figure it out, basically. But my concern is like, where do our amendments rights come in? Because like, if Dateline just got it from basic journalists doing their job, like, is that really a crime? No, they're just good journalists. They went and did what they had to do. So to get that content for the Dateline. Now, if someone leaked something, that's a different story. I haven't watched it myself, so I'm going to watch it tonight. Let's come back here and regroup tomorrow or whenever I watch it, and we can talk about it. I wish it was something we can stream on YouTube, but YouTube will copyright you. So no can do there. But, my heart goes out to the victims' families. It sucks. I'm sure we've covered a lot of the Idaho 4 case here. So make sure you check out that playlist. And we have watched Steve Goncalves, for example, just talk about what a toll it is and how they just want justice. So that's something that I do definitely think sucks. And, I know that's probably not easy. So we'll see what happens. It's not a guess. I know it is. It really is. Okay, so come now, Bryan C. Kohberger, by through his attorneys of record, respectfully submits the following motion to continue due to the substantial amount of trial investigation and preparation still outstanding, as well as recent forthcoming publicity that is highly prejudicial to the defense. Any conviction and sentence resulting from a capital trial beginning in August of 2025 will be unconstitutionally imposed and therefore vulnerable to reverse on direct or collateral review. In making this motion, Mr. Kohberger relies on his free right to be free from cruel and unusual punishment, his right to due process, his right to a fair trial, and his right to counsel, his right to present a defense, his right to confront witnesses, his right to a fair and reliable sentencing determination, and other rights safeguarded by the 5th, 6th, 8th, and 14th Amendments of the United States Constitution. So, argument 1. Hello, Chief. Yes, I want to understand what actually happened with Dateline without having to actually watch it. I haven't watched it. I know I'm late on it, fam. I will report back here. I know a couple of my mods have watched it. Somebody told me earlier today, it's wild. So I really do want to get into it. I'm so glad you're here, Augie. Good to see you, love. This court has an obligation to uphold Mr. Kohberger's constitutional rights by vacating the trial date because defense counsel needs additional time to review discovery and prepare for the complex merits and sentencing phases unique to death penalty cases. This court has an obligation to enforce the constitutional rights of all persons, including prisoners. As detailed in this motion, moving forward with a capital trial in August will infringe upon Mr. Kohberger's constitutional rights as counsel requires more time to review discovery, complete investigations, and prepare for trial. When considering this request for a continuance, the court must weigh the issues against the heightened need for reliability in death penalty cases. This elevated standard is essential because execution is the most irreversible and profound penalty. Indeed, death is different. When the state seeks the death penalty and imposes an extraordinary burden upon the court itself and the defense counsel to ensure the fairness, accuracy, and reliability of the trial and any subsequent sentencing proceeding. With a defendant's life at stake, the trial court must, quote unquote, particularly be sensitive to ensure that every safeguard is observed and must take extraordinary measures to ensure that a death sentence is reliably imposed rather than imposed out of whim, passion, prejudice, or mistake. Justice O'Connor, occurrence in Thompson versus Okla, reinforces the idea that trial courts must apply heightened scrutiny to decisions potentially leading to a death sentence. The Idaho Supreme Court, too, has emphasized the special safeguards and stringent due process protections that must be afforded in capital cases. Because proceeding to a capital trial prematurely is a decision that may lead to the erroneous imposition of the ultimate sanction, this court must consider and assess this motion under a heightened standard of due process. Mr. Kohberger has a myriad of constitutional rights during these proceedings, all of which are dependent on counsel having the time and resources to prepare for a capital trial in accordance with established professional norms. In capital cases, the rights to the effective assistance of counsel and a complete defense are amplified. The Sixth Amendment entitles Mr. Kohberger to the effective assistance of counsel at both the merits and penalty phases of this capital case. Additionally, and concomitantly as part of the Sixth Amendment guaranteed, as well as his right to due process as protected by the 14th Amendment, Mr. Kohberger is entitled to a sufficient amount of time to allow counsel to adequately prepare for trial and sentencing. The Supreme Court has recognized that depriving a person of counsel during the period prior to trial may be more damaging than denial of counsel during the trial itself. I'm like, why are they covering this? They're not being denied, right? I'm confused. In a capital case, counsel must meet specific professional obligations to be constitutionally effective. The ABA guidelines outline the professional expectations and obligations for counsel in death penalty cases. These guidelines are not merely aspirational. They represent the current consensus on what is necessary for effective representation in capital cases. The Supreme Court has consistently referred to the ABA guidelines to determine the prevailing professional norms for counsel's profession. For example, in Wiggins versus Smith, the court complained that the ABA guidelines for capital defense serve as guides to determining what is reasonable and represent well-defined norms. Similarly, in Rompilla versus Beard, the court emphasized that it is a lawyer's duty to conduct a thorough investigation of the case's circumstances and explore all avenues leading to facts relevant to the case merits and the penalty if convicted, citing the ABA standards for criminal justice. Okay, so they're talking about they want to do like an investigation into everything that came out, I assume. The Ninth Circuit, which would review any death sentence arising out of Idaho state courts, has repeatedly relied on the ABA guidelines and expressly recognized the guidelines as a proper measure of adequacy of an attorney's investigation. The Ninth Circuit is not an anomaly. More than 700 capital cases opinions cite the ABA guidelines. In addition to the effective assistance of counsel, Mr. Kohberger has a right to a meaningful opportunity to present a complete defense. California versus Trombetta. Okay, I want to skip that part. This right has a number of sources, including the Due Process Clause of the 14th Amendment, as well as the Compulsory Process and Confrontation Clauses of the Sixth Amendment. This right takes on special significance in capital cases. The right to present a meaningful defense must take a precedent over any countervailing state evidentiary rules or other procedures that might be acceptable in the context of non-capital criminal cases. Mr. Kohberger is also entitled to an individualized sentencing determination, a constitutional right that is unequally reserved for the defendants facing the death penalty. I mean, he is facing the death penalty. Part of the problem with not coming around consistently. Oh, I see what you're saying. Hey, HCB. I mean, it is the death penalty. I do keep I do understand why they keep trying to, make sure that the defense can do what they can, but I don't know. I have to watch the state line thing to know more. Definitely. Okay, let's see. Because the prosecution is seeking to execute him, Mr. Kohberger also has identified constitutional rights in this proceeding. The Eighth Amendment requires that a capital sentencing proceeding permit individualized consideration of the defendant and the circumstances of the offense. I'm going to skip some of where they touch on previous cases. As the Supreme Court noted in Edmund versus Florida, we insist on an individualized consideration as a constitutional requirement in imposing the death sentence, which means that we must focus on relevant facets of the character and record of the individual offender. The U.S. Supreme Court has repeatedly emphasized that in a capital case, a jury must be given the opportunity to consider all evidence that may weigh against a death sentence for any particular offender. This evidence includes anything at all from the defendant's life history and cannot be limited. Explaining that a sentence may not be precluded from considering as a mitigating factor any aspect of the defendant's character or record and any of the circumstances of the offense that the defendant proffers as a basis for a sentence less than death. I'm going to skip some of this. Relevant mitigating evidence is evidence which tends logically to prove or disprove some fact or circumstance which a fact finder could reasonably deem to have mitigating value. Thus, a state cannot bar the consideration of evidence if the sentencer could reasonably find that it warrants a sentence less than death. When a jury is denied relevant mitigating evidence, either because counsel independently fails to conduct a complete investigation or because the court denies counsel adequate time or resources to conduct such an investigation, the defendant's rights under the 6th, 8th, and 14th Amendments of the U.S. Constitution, as well as the corollary guarantees in the Idaho Constitution, are violated, and any resulting death sentence cannot stand. Thus, individualized sentencing requires the presentation of mitigation evidence that is properly investigated, documented, and presented with the help of appropriate experts. As detailed further below, this process is a comprehensive, time-consuming, and expensive undertaking, but it is also what our Constitution demands when the government seeks to extinguish human life. So they're basically making the points as to why they need to delay the trial. And that if his defense team doesn't get time to look into everything, of course, it's not fair to Bryan. I know that there's a lot of information coming out on that Dateline thing. I don't know if this is why this arose from it, or if they just simply do really need more time. But, like, how much more time? Because it's been going on forever, right? It seems like. Hey, eyes never lie. The right to qualified expert assistance is part of the guarantees to effective assistance of counsel and an individualized sentence proceeding. In line with the heightened protections afforded to capital defendants and stemming from both rights to a meaningful opportunity to present a complete defense, capital defendants are entitled to necessary expert assistance. Indeed, expert assistance is needed in all homicide cases, given that investigating a homicide is uniquely complex and often involves evidence of many different types. Analyzing and interpreting such evidence is impossible without consulting experts, whether pathologists, serologists, microanalysts, DNA analysts, ballistic specialists, translators, or others. However, in a case where the prosecution elects to seek the death penalty, the right to access competent expert assistance is particularly important, given that the prosecution and the defense rely more extensively on experts in death penalty cases than in other types of criminal cases. Beyond the frequently complex merit phase issues, conducting an adequate investigation into sentencing phases issues in a capital case almost always require the assistance of multiple experts. We know that. Explaining that when a capital defendant's mental condition is seriously in question and is relevant to the punishment he might suffer, a state must provide a mental health professional capable of conducting an appropriate examination and assisting in evaluation, preparation, and presentation of the defense. As discussed further below, defense counsel cannot know the full range of experts that may be necessary until after the extensive social history investigation has been completed. Both the identification of a mental health professional's necessary area of expertise and the accuracy of the expert's diagnosis is dependent on having accurate and comprehensive social history information. Wait, so now there's talking about his mental health again? What? Counsels, we do know, the whole autism, whatever Bryan thinks his issues are. Counsel's professional and ethical obligations in a capital case. In order to effectuate Mr. Kohberger's constitutional rights as described above, counsel must meet at least the minimum professional obligations for counsel on a capital case as outlined in the ABA guidelines. The ABA guidelines require high-quality legal representation for all persons facing the possible imposition or execution of a death sentence by any jurisdiction. Among many other things, the ABA guidelines recognize that every task ordinarily performed in the representation of a criminal defendant is more difficult and time-consuming when the defendant is facing execution. Due to the extraordinary and irrevocable nature of the penalty at every stage of the proceedings, counsel must make extraordinary efforts on behalf of the accused. With respect to investigation for, my computer just glitched. To the investigation for the merits phase, the ABA guidelines are clear that a counsel must thoroughly investigate and challenge every minute piece of the evidence the state purports to have. To assume the accuracy of whatever information the client may initially offer or the prosecutor may choose or be compelled to disclose is to render ineffective assistance of counsel. The defense's lawyer obligation includes not only finding, interviewing, and scrutinizing the backgrounds of potential prosecution witnesses, but also for searching any other potential witnesses who might challenge the prosecution's version of events and subjecting all forensic evidence to rigorous independent scrutiny. In addition to a complete investigation of every piece of the state's case, counsel is then responsible for identifying and considering all legal claims potentially available if these claims have consistently lost in, even if those claims have consistently lost in the jurisdiction. This is necessary because counsel in a capital case has a duty to preserve any and all inconceivable errors for each stage of appellate and post-conviction review. Non-preservation of an issue at the trial level may result in a waiver. Describing a case in which, from a joint capital trial, one co-defendant was eventually executed because his counsel failed to object to women being excluded from the jury, while the other co-defendant's case was reversed and now he's serving life in prison. So do you guys think, if you have watched period, without the Dateline thing, do you think that this trial should be delayed? Because what do you think? Like, do you think that this is a fair request? Do you think, no, they've had enough time, they're just pushing it out? Or do you think because of the new information being released and it being a death penalty case that it's fair that they want more time? Hey, Spawn Dog, good to see you. Hey, Knight, good to see you. We're talking about Bryan Kohberger. Okay, we're reading the motion to delay trial, basically. They're asking to delay the trial that's supposed to start in August that we're all so eager to see. This obligation, let me know if you've seen the Dateline episode too, by the way. This obligation places a significantly higher burden on a defense counsel than in a non-capital case. In an ordinary criminal case, counsel could strategically forego some aspects of the exhaustive investigation outlined step by step in the ABA guidelines and would not be required to preserve every possible legal error for potential review. Furthermore, there would be significant fewer legal issues to address because the unique issues related to capital sentencing would be irrelevant. I think more time is fair with the low amount of evidence. Yeah. Hey, Killa. Counsel must conduct an exhaustive, unparalleled life history investigation, analyze hundreds of documents and interviews, and compile all of this information into a cohesive narrative for sentencing phase. Did they already know that? Like, it's a death penalty case. I mean, didn't they conduct a life history investigation before? What does that even mean? What a constitutionally adequate investigation entails. There we go. I'm like, what? They're going to look into his deep, like what? Start from the time he came out of the womb until he was a toddler. And then they're going to talk to all his cousins, his grandmammy. Like, they're just going to go down the road or what? Like, what are they going to do? Because what does that mean? Like what he was like in middle school. They want to know if he was like killing animals before he did this, that kind of thing, or what? Hey, Jules. A constitutionally adequate investigation for the sentencing phase of a capital case requires a comprehensive investigation into the client's entire life history in order to present a complete picture of the client's mitigating life circumstances to the jury. Because the sentencer in a capital case must consider in mitigation anything in the life of the defendant which might militate against the appropriateness of the death penalty for the defendant. Penalty phase preparation requires extensive and generally unparalleled investigation into personal and family history. I'm like, what's in that Dateline episode about like his history in the family? I'm curious because I haven't watched it. I might watch it tonight. Well, maybe not because I'll be here, but maybe tomorrow. I'm curious what they are talking about. Because didn't they already do this? Hasn't it already been like 2 years, 3 years? The life history investigation is so central to the death penalty cases that there is a supplementary set of guidelines specifically outlining counsel's responsibility in this piece of preparation. Supplementary guidelines. I mean, it might not hurt to take a look at those. The defense must conduct an ongoing, exhaustive, and independent investigation of every aspect of the client's character, history, record, and any circumstance of the offense or other factors which may provide a basis for a sentence less than death in order to meet their constitutional obligations. I don't understand. They want to know about his history, but like, why? Unless he has something going on with his brain, nothing is going to justify him killing 4 students in a matter of minutes, brutally slashing their throats and unaliving them. I'm sorry. It's a little brutal, but it's just the truth. I mean, Sally telling me that he was bullied in the 3rd grade and for whatever reason, it's not going to justify that he killed these college students. Do you know what I mean? I mean, I can take it into account, but I don't know. How do you feel about that? Maybe I'm being too harsh. Dozens of cases confirm this as a fundamental obligation of defense and counsel in a capital case. Without conducting a reasonable investigation, counsel's choice of strategy will be arbitrary as the strength of each potential strategic choice is contingent on the outcome of the initial investigation. Compiling a comprehensive life history for a capital sentencing phase requires 2 primary responsibilities, which are dependent upon each other as further explained below. These responsibilities are 1, collecting and analyzing records from the client and the client's family's life history, and 2, interviewing individuals who have touched the client's life or who may be able to shed light on the circumstances shaping the client's life. Interviewing individuals who have touched the client's life. It is well established that life history records that must be collected include, but are not limited to, all records that may be in existence and which may bear any of the following subjects: medical history, complete prenatal, pediatric, and adult health information. I was being sarcastic when I said, oh, they want all the information from when he came out of the womb. And they're literally saying that. Complete prenatal, pediatric, and adult health information. I thought I was just being a smartass. Exposure to harmful substances in utero and in the environment, substance abuse history, mental health history, history of maltreatment and neglect, trauma, educational, employment and training, military experience, multi-generational family history, genetic disorders, prior adult and juvenile correctional experience, religious, gender, sexual orientation, ethnic, racial, cultural, and community influence, socioeconomic, historical, and political factors. Contemporaneous records are intrinsically credible and may document events which the client and other family members were too young to remember, too impaired to understand and record in memory, too traumatized, ashamed, or biased to articulate, or events which the client knows nothing about, but which may document significant events or condition in the client's life. In addition to collecting and analyzing those life history records, the defense team must identify, locate, and interview life history witnesses in a culturally competent manner in order to produce confidential, relevant, and reliable information. Lay witnesses that may be interviewed include people such as the client's family, extending 3 generations back, the client's friends, teachers, classmates, coworkers, employers, and those who have served with the client, as well as those who are familiar with the client's early and current developmental and functioning medical history or environmental history, mental health history, education history, social service and treatment providers to the client and the client's family members, including doctors, nurses, and medical staff, social workers and housing or welfare individuals, witnesses familiar with the client's prior juvenile and criminal justice and correctional experiences, former and current neighbors of the client and the client's family, witnesses who can testify about the applicable alternative to a death sentence and or conditions which the alternative sentence would be served, witnesses who can testify about the adverse impact of the client's execution on the family and loved ones. Oh my God. It is vital that the interviewer conduct these interviews in person, face-to-face, and one-on-one, and that multiple interviews be conducted to establish trust and rapport in order to elicit sensitive information. So they're going to like interview everyone in Bryan's life. Augie says, I don't want to see any life story used as any excuse. Right, Augie. I wonder how nurtured he was. Anyone know? Not at all. Augie, it's like they're trying to give him a sob story. They are. It will be interesting to see what comes out in the trial. I have a lot of things to say about this. Like, we don't care. We don't care. Right? Like, we don't care. Okay, well, I'm being rude. We do care. Like, if he experienced trauma, we do want to take that in account. We do want to, his mental health, that is important, et cetera, et cetera. But now they're bringing it up after people have just looked into his past a little bit, which means that they should have done that. I mean, they're doing that in the pig vomit case, Stephen Stearns. They digged up, his roommates, et cetera, et cetera. Like, didn't they already do all of this? I'm just confused because some information was probably let out about his past or something, right? As the mitigation investigation develops, red flags will become apparent. Indications that a particular mitigating circumstance or theme may be present in the defendant's life history. When counsel discovers a red flag, it cannot be ignored. The development of the mitigation investigation, including the identification of and subsequent follow-up on red flags, is dependent on both the life history records and interviews of these witnesses. These two parts function together in order to produce a reliable life history narrative. For example, records from a client's visit to the emergency room might be evidence of physical maltreatment by a parent or caretaker and may establish relevant dates and identify potential witnesses. The author of reports and documents are themselves potential mitigation witnesses unknown to the client and family. Alternatively, a family member recalling that the client or his family received services from a community organization when the client was young may aid counsel in finding records that would have otherwise not been known to exist, and which will offer third-party and contemporaneously record insight into what life was like for the client at a very young age. In this way, the investigation necessarily expands as new information is learned, because each record obtained will refer to other records and reports which must be obtained and individuals who must be located and interviewed. The cyclical investigation is also important because it leads to confirmation from multiple sources, both objective records and corroborating witnesses who can testify, producing a persuasive mitigation case that can withstand adversarial testing. Thus, mitigation investigations develop in stages as explained in this example. Records indicating that the client's mother drank alcohol during her early teenage years would lead the mitigation specialist to question her mother, her family, and her friends regarding the history of the alcohol use, particularly whether she drank during pregnancy. To test and corroborate the responses, the mitigation specialist would gather the mother's school records, medical records, especially prenatal and postnatal healthcare records, and all mental health care records and substance abuse treatment records, the client's birth records and pediatric records, as well as school records, social and academic problems, as well as psychological evaluations, and social service or child protection agency records. Additional interviews would follow, focusing on the family's members, neighbors, coworkers, caregivers of the mother, and the client, who may have information about the mother's use of alcohol during pregnancy and the effects this had on the client. All of this information might give rise to a theory that the client suffers from fetal alcohol syndrome, which in turn would lead to further evaluation by an appropriate mental health expert. All these steps are absolutely necessary for an accurate and reliable diagnosis by the expert evaluator. Oh my gosh, what the heck? Unsurprisingly, this process takes time, especially because many witnesses must be interviewed multiple times even after report has been established. It is insufficient to talk to witnesses only once because each new individual recalls different facts and anecdotes. If an aunt provides an account of a head injury, which the mother might forgot to mention, it is necessary to go back to the mother and ask it. Similarly, an interview may reveal records that must be obtained, which in turn raise new questions which necessitate interviewing several witnesses again. So they're saying they need all the time in the world for this. Hey, Barrywood, good to see you. Hey, Jeff. Well, he has everyone already made up that mine's on theirs, dude. His brow hair will smell bad on that electric chair. The bushy brows. I think we should watch a trial with an open mind and not have a confirmation bias. Okay, you're right, Fem. That is true. But I mean, again, like, what am I missing here that got leaked on the that episode? Like, did they go back into his past and realize something with his parents or something? Because like all of a sudden now they want to do a whole comprehensive history review, like, seems a little odd. Adding to the complexity, it has long been recognized that a competent mitigation investigation must include the family history going back at least 3 generations and must document genetic history patterns and effects of familial medical conditions. Because it is well established that many major psychotic illnesses have strong genetic components, the existence of mental illnesses or related conditions in the family tree is vital information for mental health experts evaluating the clients, and the absence of such can lead to an incorrect diagnosis. The ABA guidelines are clear that this exhaustive investigation is constitutionally required, despite the fact that it is a time-consuming and expensive undertaking. A multi-generational investigation extending as far as possible vertically and horizontally frequently discloses significant patterns of family dysfunction and may help establish or strengthen a diagnosis or underscore the hereditary nature of a particular impairment. The collection of corroborating information from multiple sources, a time-consuming task, bolded, is important wherever possible to ensure that the reliability and thus the persuasiveness of the evidence. Hey, Abuelita's journey. They have to include mitigating factors. Haven't they been doing that though, Abuelita's journey? That's what I want to know. What have they been doing the last 2.5 years? Pretty sure a few people in this chat have a reference. So, right, Jeff. Yeah. That's true. His sob story has nothing to do with anything. These people, right? Yeah, his sob stories have nothing to do with why he cut 2 people's throats. Unless he had a real mental health condition, I really don't want to hear about it. You know what I mean? Or like fetal alcohol syndrome, but we thought we would have heard of that when the autism thing came out, right? I don't think that's the case here. A full investigation is likely to lead to the discovery of numerous mitigating factors that would not be readily apparent from a cursory investigation. Records and interviews and other psychosocial research collected during the mitigation investigation process may reveal the following types of information, all of which has been considered mitigating in the modern era of capital punishment. Fetal and birth trauma, problems in early physical, emotional, mental, and social development, physical illnesses and impairments, such as infections, high fevers that compromise organic function, traumatic injuries, and infectious diseases. Evidence of early or adolescent signs of mental illness or deficiencies, educational history, including when and where the client attended school, patterns of social behavior, including acting out in anxiety or tendencies towards isolation, the history and nature and extent of psychological, physical, and sexual abuse, including molestation and rape, a history of course of self-medicating behaviors and subsequent drug and alcohol dependence, the nature of relationships with parents and nuclear family and extended family. Wow. Residential history, presence or absence of social and community support systems, nature and extent of poverty, including substandard living conditions, the number and nature of traumatic events, employment history, juvenile and adult criminal history, military history, patterns of all significant relationships and any indications of attachment disorders, physical and mental health, substance abuse, social education, and employment histories of parents, caretakers, siblings, and other individuals. Oh my gosh, they need to know like everything. It sounds like they're literally trying to use stuff like his professor's writing as evidence against him. Runkle pointed that out, even as true crime fans probably have weird such. I agree. I agree, though, fam. They really are trying to use anything. Does this guy have everything in the world wrong with him when he was young? Right. Yeah. No. They're just using it to delay. Hey, Tony. Mere identification of mitigating information is not the conclusion of the investigation. Though it requires many hundreds or thousands of hours to complete the interviews and record record collection in constitutionally adequate manner, the mere identification of mitigation themes such as those listed above is not the conclusion of the investigation. Counsel must then analyze each theme in accordance with available empirical and social science, usually with the help of experts, and must decipher how each mitigating theme played a role in the client's life. For example, childhood poverty is a common mitigating theme in capital cases. What are they doing? Simply knowing that a client's family was very poor is insufficient. Social science has extensively documented how poverty can snowball into other major problems, such as an increase in likelihood of physical and psychological abuse, antisocial behaviors, long-lasting psychological effects, and such as depression, poor impulse control, and high levels of dependency, increased likelihood of diagnosable psychiatric conditions, increased likelihood of trauma, which can result in serious long-term consequences, both physically and psychologically, parental abandonment or neglect, increased exposure to environmental toxins and pollutants, dangerous living conditions, poor quality schools, and so on. Wow. It is incumbent on the defense team, therefore, to investigate beyond the mere surface level identification of mitigating factors. The contextualization and integration of mitigating life history information is an essential part of the capital sentencing decision because jurors ultimately are looking for an answer to the question of why. For example, the long-term consequences of poverty can be empirically documented. That documentation can serve as the solid factual scientific basis for the penalty phase contention that childhood poverty, over which virtually no capital defendant has had any control, helped to shape his life course, drastically limited his available choices, and contributed directly to the criminal behavior and lifestyle in which he engaged. And it is usually possible to identify with some precision the various factors that help to explain why some people's lives are more profoundly affected by poverty than others. This is unbelievable. Now they really are going to go look into everything. Yeah, I feel sorry for him if he haven't unalived people brutally. Right. Most of us have had traumas, problems, etc. Right. I think I learned so much growing up poor. In sum, compiling a life history is not merely a checklist of tasks. It is a complex and rich endeavor that focuses on a person's identity and goes to the heart of human experience. Compiling a life history includes understanding the broader environment that affects the client, and this requires gathering records and asking questions regarding of cultural, class, race, and ethnicity, national origin, gender identity, sexuality, spirituality, and other factors that affect the client's individual identity and group allegiances. This is not a tangential inquiry. Rather, how a person perceives himself and his place in the world affects his motivation and understanding of how his conduct, status, and interpersonal relationships, safety, honor, and obligations. Identity profoundly affects how medical and mental illnesses are described and experienced by an individual and his community. How others perceive an individual and his place in the world adds an additional layer of complexity to understanding the nature and magnitude of psychosocial stressors he encounters. I really would like to know if all these factors are really taken in account in all of these death penalty cases like that we see, like some guy was just put to death in like Florida last week. Like I would like to see the review of the life history. Like, do they actually do this with everyone, or is it just the people that get, have the money or the big cases? Like, this is crazy. And why didn't this come up before? Just wondering. Without this information properly investigated and contextualized, it is impossible that a jury will be able to conduct an individualized sentencing of the defendant and his circumstances that the Eighth Amendment requires. Like pollutants, like what he picked up dogs. His dogs, no bees, because bees are considered too, right? They are weeding all this out. It is a lot to dig into the mitigating factors, especially for LWAP. Yeah, I get that, but like, did they not think about this prior to 2 months before his trial is supposed to allegedly start? Hey, Jahira, good to see you. I don't get it. Why is it coming up just now? That's my concern. It should be noted that an integrated, comprehensive life history is not a luxury to be afforded to only some capital defendants, nor is it offered as an excuse that stands no chance in the face of an aggravated crime. Rather, it is a vehicle that confronts and challenges the stereotypes of the natural-born killer, offering instead an examination of the structure of the lives of those who commit capital violence. The Supreme Court has recognized that a fundamental and mandatory part of the capital punishment system is that a process that accords no significance to relevant facets of the character and record of the individual offender or the circumstances of the particular offense excludes from consideration in fixing the ultimate punishment of death the possibility of compassionate or mitigating factors stemming from the diverse frailties of humankind. It treats all persons convicted of a designated offense not as uniquely individual human beings, but as members of a faceless, undifferentiated mass to be subjected to the blind infliction of a death penalty. Moreover, there are many examples of capital cases in which the presentation of a comprehensive life history and mitigating circumstances overcame aggravated crimes, including cases with multiple victims. Oh, I see where they were going with that. I see. Indeed, juries have rejected the death penalty in at least 400 cases involving multiple victims, demonstrating the outcome of this case, even in the event of conviction, is anything but a foregone conclusion. So maybe like some kind of comprehensive life history detail might change, or the jury's mind. Maybe they'll have more empathy towards whatever that thing is. I don't know. That's ridiculous. But I guess, hey, that's the law. For example, Ricky Abeda killed a state police officer, a sheriff's deputy, his ex-girlfriend, along with her 18-year-old daughter, an adult sister, another teenager, and a 6-month-old baby in a small New Mexico town of 2,500 residents. A jury sentenced him to life after deliberating for 11 days. What does that have to do with the comprehensive? I'm like, what about Ricky Abeda changed their mind? That's a crazy. case. We should probably look into that. Jason Burkett and a co-defendant killed 3 people, including a 16 and 18-year-old in 2 separate episodes. A Texas jury sentenced him to life. Oh, they're trying to make a point. Now I get it. They're trying to make a point how like Bryan killed 4 people and he got sentenced to life rather than the death penalty. I got it. Andre Cooper was a gang leader convicted of unaliving 4 people, including eliminating a witness against him. A Pennsylvania jury rejected the death penalty. The list goes on. Okay, I got what they're trying to do. What do you think? I'm curious in the comments. Do you think that Bryan deserves the death penalty? This shouldn't be allowed, right? I need to pipe in. I'm 56 and have been polluted with parents smoking in the car with the windows and all kinds of stuff. And I never harm. So thank you, domestic. That's what I'm trying to get at. I'm like, really now? Really? Two months before the trial, now they care about the pollutants that Bryan Kohberger inhaled because they think that for some reason that made him lie and say he was stargazing after he unalived 4 college students where his car was located. Oh no, but he was stargazing and blame it on the pollutants because that's why he was out there stargazing, right? I think I can't say if he deserves the penalty without seeing the child, right? Fair, femme. But if you did, please don't. A death sentence is not a guaranteed outcome upon conviction of an aggravated capital unaliving case. And in the case where the allegations are sensational in nature and have been the subject of intense media and public scrutiny, a comprehensive and accurate life history presentation is even more crucial to the constitutional imperative of an individualized sentencing determination to ensure the aggravated nature of the crime and the public outcry does not overcome the jury's ability to weigh both options. Didn't they ask for change in venue? Like, was that not enough? Like, life without the possibility of parole. That's what Demi thinks. Okay. That's right, Ungi. Yeah, I don't think anyone deserves, we have no say in that, I think. But I don't know, sometimes an eye for an eye, and you know where that comes from, but you know what I mean? I think it's human. Some of us think like that. Right, Jules, right. Oh my gosh, that's crazy. Or like something like, before that law came in effect, the Sharpies, how people were like inhaling Sharpie. Oh my God, like we could probably use that an excuse. Like in an elementary school, we still had Sharpies and whiteout around. And that made me unalive someone 32 years later. LWOP is torture. 25 years to life is plenty of punishment. Yeah. I think that's fair too. I am not Jesus and I am not the judge. So with that being said, I need to know a little more, I think too. Like the BPH makes sure the cuckoo stays. Thus, capital defense teams have a complex and time-consuming job in identifying and interviewing life history witnesses, collecting numerous life history records from the client and his family, and then analyzing and contextualizing all the information into a cohesive narrative for the jury, should the case proceed to a sentencing phase. And as discussed in the following section, it is only after the mitigation investigation nears completion that counsel can identify all of the behavioral, cultural, scientific, and mental health experts that may be necessary to develop the mitigation presentation and allow for individualized sentencing as required by the U.S. Constitution. In addition to frequently complex merit phase issues that are likely to require expert assistance, adequate investigation into the sentencing phase issues almost always require the assistance of multiple experts. In particular, the defendant's mental health and cognitive functioning throughout life, as well as that of family and caretakers, is essential information during the sentencing phase and also pertains to merit phase issues. Like other mitigating circumstances, merely identifying mental health diagnosis is insufficient to tell the client's story. Understanding how mental disorders, impairments, and trauma affect a client's childhood, adolescent, and adult functioning are core responsibilities of the capital's defense function. Reliable mental health assessments depend on extensive life history information, including information about family and genetic histories. Moreover, in addition to basing evaluations on reliable and complete life history information, experts must be selected on the basis of specific red flags in the client's history and each expert's specialty. They cannot be generalized forensic practitioners brought in to look for any variety of potential diagnosis. Experts that may be necessary in a capital case come from a variety of specialties and may include medical doctors, psychologists, psychiatrists, neuropsychologists, neuropsychiatrics, endocrinologists, toxicologists, pharmacologists, and various PhDs, such as PhDs in childhood development or early childhood education. Within each of these professions, there are a host of specialties that must be tailored to the case, such as childhood abandonment and neglect, complex trauma, intellectual disability, traumatic brain injuries, fetal alcohol syndrome, in utero exposure to substances, effects of specific drugs or substances in combination with existing disorders or mental illnesses. In light of the facts that experts with different specialties will be necessary for each case, decades of case law confirms that it is simply ineffective assistance for counsel to permit a mental health assessment of the client to occur before having made a reasoned decision about the purpose of the examination and having provided the examiner with the data necessary to reach a professionally competent conclusion respecting the question presented. Experts are often essential to telling the client's story in which a way that answers all the important why questions and connecting the client's life circumstances to the commission of the crime. Manson had people do history. It is a thorough motion. It is absolutely. It's pretty good. A deeper understanding of the subject is rendered through a psychodynamic formulation, which takes into account influences in a subject's life that contributed to his mental state and considers how environmental and personality factors are relevant to analyzing the subject's symptoms, and considers how all these influences interacted with the person's genetic, temperamental, and biological makeup. For example, using attachment theory, a commonly accepted theory of human behavior, a mental health expert might describe the long-term consequences of being raised by a parent who was psychologically and emotionally unavailable to the defendant as a result of the parent's severe depression or drug addiction. A mental health expert might also employ research on the impact of various factors on human growth and development to explain how certain traumatic injuries to the defendant's brain or exposure to certain chemical toxins or a certain chronic medical condition resulted in cognitive deficits or behavioral difficulties. In another case, a mental health expert might use research that has clearly demonstrated the effects of a particular drug of abuse on human behavior to explain the behavior of a defendant who was addicted to the drug or ingested large quantities of the drug, or both. Conversely, a mental health expert might explain how a defendant's inability to comply with a prescribed medication regimen resulted in the reoccurrence of hallucinations, delusions, and/or thought processes that led to the criminal behavior. There are numerous examples of capital case reversals because counsel failed to complete the social history investigation, even when competent experts have been hired, because the evaluations resulted in inaccurate or incomplete information presented to the sentencer. There you go. And it's bolded. That was the whole point of that. That's what they wanted to say. So something in maybe his past or history his capital case can be reversed, or should be, whatever they find to be lawful, right? Okay, let's see. This is interesting for sure. Jacobs versus Horn, overturning conviction and death sentence because counsel was ineffective for failing to provide the hired mental health expert with the social history necessary information to conduct a proper evaluation. And the expert erroneously concluded that defendant suffered no major mental illness when in fact the defendant suffered from mild mental retardation, organic brain damage, and schizoid personality disorder. Conviction reversed because this information would have been relevant to a diminished capacity defense. So that was like an example of a case in 2005. Gels versus Mitchell, 2008, finding counsel ineffective for failing to investigate the defendant's social history. Okay. Hey, if it's gonna give them what they want, I guess. I don't want to see a mistrial. Commonwealth versus Collins, 2005, including by a failure to provide defense psychiatrists with relevant history. So it's really a thing. Therefore, the investigation into the individual's life history must be completed before counsel can know the full spectrum of necessary experts for the penalty phase. So they're saying that before they get all the experts for the penalty phase, all of this must be reviewed. How long is this going to take? Like 500 years? This is essential because the accuracy of the evaluation relies on precise background information, and counsel must identify the appropriate type of expert to engage. Forensic neuropsychologist George Wood emphasizes that the accuracy of a diagnosis is contingent on the social history, and cognitive deficits are likely to be overlooked if a comprehensive social history is not complete. This is because, quote unquote, cognitive deficits often present as a series of defective links in an action, particularly in a new, novel, or stressful circumstance, rather than discrete symptoms like hallucinations or delusions. This information cannot be obtained solely through face-to-face evaluation in a jail setting. Excuse me? So are they trying to take Bryan somewhere or to a facility? Like, what are they, like what? Not in a jail setting? The ABA guidelines highlight the complexity of this process and acknowledge that creating a competent and reliable mental health evaluation consistent with prevailing standards of practice is a time-consuming and expensive process. No, that's not happening in August. Praying for our children. I know. I believe this journey. Me too. Mental hospital? They want Bryan in a mental hospital. Is that what you're saying? Is that what they're saying here? They want him to be evaluated or what? Hi, Thomas. This is not. You guys really think that it's not going to get delayed? I think it might get delayed. I don't know. Someone earlier told me that they think it won't get delayed. That Hippler is going to be on it. Counsel requires additional time to fulfill the minimum requirements described above. As counsel explained in recent filings in an oral argument, which are hereby incorporated in full for brevity's sake, it is impossible for the defense team to review necessary and relevant discovery in a manner that allows the evidence to be integrated into the comprehensive defense case, to pursue all necessary investigations arising from review of the discovery, including into alternative perpetrators, and to address the myriad issues that continue to arise from the state's failure to fully abide by the court's discovery and expert disclosure deadlines. Counsel requested that this court alleviate these problems by precluding the death penalty as a possibility, freeing up counsel's time to focus only on the merit phase preparation and remove the heightened standard of reliability that governs the death penalty proceedings. Because the court denied that motion, counsel is obligated to seek a continuance to continue reviewing discovery, complete investigations relating to the merit phase, including into alternative perpetrators, and complete investigations into red flags that have arisen in the life history investigation. I got it. So the alternative perpetrator thing, okay, they need more time, and the red flags that have arisen from the Dateline episode. Right? Am I right or no? Sounds like it. Courts have recognized that the prosecution has an advantage in investigation and discovery issues because of the resources at their disposal, and this is particularly true where the prosecution has had the assistance of the federal government. They're trying to decide where to house him. Wow. Really? Because their computers and dust screens are going to steal their air cleaner for the Jules. ADX Lawrence is where he needs to go. Yeah, I'm shook. This is happening. I'm shook. The Supreme Court's rejection of the idea that the prisoner still has the burden to discover the evidence is based in part on the fact that the prosecution has the advantage of a large staff of investigators, prosecutors, and grand jurors, as well as new technology such as wiretaps of cell phones. That is one of the reasons the investigators must assist the defendant who normally lacks this assistance and may wrongfully lose his liberty for years if the information they uncover remains undisclosed. The superior prosecutorial investigatory apparatus must turn over this exculpatory information. The Brady Rule imposes an independent duty to act on the government, like the duty to notify the defendant of the charges against him. The prosecution has not provided defense counsel with a list of potentially exculpatory or impeaching evidence within the vast trenches of discovery in the case, and the court declined to order them to do so. Wait, let me read that again. The prosecution has not provided defense counsel with a list of potentially exculpatory and impeaching evidence within the vast trenches of discovery in this case, and the court declined to order them to do so. During oral argument on that motion, the court identified a practical problem with relying on prosecutors to identify and list all the exculpatory and impeaching information. Prosecutors are advocates of their side and see the case through the lens of trying to secure a conviction. Thus, what may appear exculpatory to a defense attorney or lead to the discovery of exculpatory evidence through additional investigation may appear only tangentially relevant to a prosecutor. Given the heightened standards of due process afforded to a capitally accused defendant, it is imperative that the counsel has time to review the relevant discovery and conduct any necessary follow-up investigations. Yeah, in prison he's mental health. Oh. Cutting off this review before counsel can complete it would significantly prejudice Mr. Kohberger. The state's case is circumstantial. Mr. Kohberger was not identified as a person of interest until weeks after the crime, and after he was identified, law enforcement ceased investigating all other possibilities. While counsel can explain this in trial, every experienced trial lawyer knows that trials are essentially story battles, high stakes duels where the prosecution and defense each tell compelling narratives about the same set of events. Ultimately, the jury decides which story feels more true and more coherent. Even though the burden of proof rests with the prosecution and the defense bears no burden at all, humans are driven by narratives. That reality forces the defense to counteract the state's narrative with another compelling story. As scholars explain, where the central issue is the identify of perpetrator, even a reasonable doubt case implies a story that someone else did it, but it is a story with a huge hole and one likely to be ineffective. The jury might speculate that if the defendant did not do it, there should at least be some evidence suggesting that someone else did. And it is especially incumbent on counsel to become aware of all existing evidence, because alternate perpetrator evidence may be deemed inadmissible under Idaho law if it merely tends to mislead the jury that another person committed the crime. Who's the alternative perpetrator? Do we know anything? I'm curious. Thus, defensive counsel's review of the discovery is not merely checking a box. It goes to the very heart of the ability to prepare and present a defense. Reviewing and integrating all of the evidence in order to tell the jury a coherent counter-narrative is essential to defending Mr. Kohberger's life. The state and its superior investigatory apparatus, Tavra Supra, has spent years honing in on one specific story, that of Mr. Kohberger's guilt and ignoring all other possibilities. Defense counsel has a bigger job at not only reviewing their case for guilt, but figuring out what the state missed and exploring other alternative possibilities. The inability to review the discovery and incorporate all of the information into a cohesive defense trial would nearly guarantee that counsel cannot mount an effective defense on Mr. Kohberger's behalf. Because his life is on the line and due process must be given to its highest regard, this court should grant counsel the time necessary to ensure a fair trial. Oh, okay. I see. Hey, do fast. The life history investigation is ongoing and requires additional time and expert assistance. As more fully discussed in the ex parte supplement to this motion, the life history investigation remains ongoing. Counsel is reviewing and digesting significant new records that have been received in the past couple of months, addressing ongoing barriers to receiving important life history records, and continuing to build rapport with several key life history witnesses. As explained in the accompanying ex parte filing, the investigation to date has revealed red flags for a number of mitigating themes and issues, and counsel must fully investigate these avenues before making strategic decisions related to sentencing. As discussed in section whatever, only after a more thorough life history investigation will counsel know the range of experts that will be necessary to contextualize Mr. Kohberger's life story. Mr. Kohberger is entitled to maintain the confidentiality of the defense team's ongoing investigation. I don't really want to know Mr. Kohberger's life story. 3 years has not been enough time. Yeah, they need like 30 more years. Geez. Do we know if there's help? Yeah, that's why I was going to ask you guys. You tell me. Is there an alternative perpetrator? Tell me now what you think. You know, for a long time, I did really believe that. I did. I'm like, nope, it wasn't just him. But, you know, if it wasn't just him, you never know. You never know. But, oh no, I see the word dateline here. Let's get to this. I'll go on with my rant later. A continuance is also necessary to investigate and remedy the prejudice of highly inflammatory publicity released just weeks before the current trial date, including the recent Dateline NBC special and forthcoming book. So I'm going to watch that tomorrow because I'm staying up with you guys all night. But tomorrow I need to get on it, baby. And also the forthcoming book. I don't know if they state it here, but maybe I'm getting ahead of myself in the document. But I do know that James Patterson has a book coming out on Bryan Kohberger. And I love me some James Patterson. I do. Definitely buying that. Definitely. Did someone actually help him, or do you think he had a getaway driver? Girl, at this point, I don't know what to think. Okay, let's get to this. The case has garnered substantial public interest, and the court previously issued a non-dissemination order restricting the release of certain information to the public in order to preserve the integrity of proceedings and safeguard Mr. Kohberger's right to a fair trial. On May 9th, 2025, just weeks before his capital trial is set to begin, Dateline NBC aired a 2-hour episode about this case titled The Terrible Night on King Road. I think he acted alone, says Jahira. I'm still stuck on the whole evidence thing. I'm a science girl, so I'm like, wait. There's no evidence? Like, I'm still stuck on that part. I don't think dude had many friends. No, I don't think he had any friends either. The program includes details and materials, including video footage, cell phone records, and photographs of documents that are not publicly available through official channels. One of my besties told me earlier that Dateline thing is kind of crazy. I need to watch it. The show repeatedly emphasizes the non-public nature of this information, stating that it was obtained from unnamed sources who are close to the investigation, and that materials were obtained exclusively by Dateline. Much of the investigative material presented by Dateline was taken out of context and will not be admissible at trial because it lacks reliability. The leaked materials appear carefully curated to promote a narrative of guilt. As this court acknowledged in its May 15, 2025 Document and Records Hold Order, the source of the leak is most likely someone currently or formerly associated with law enforcement or the prosecution team. What? If that is the case, it raises urgent and serious questions about the objectivity, judgment, and credibility of individuals tasked with investigating and presenting the state's evidence, particularly those who may be called as witnesses. The identity of those involved, their motives, and any efforts to conceal their conduct go directly to the heart of witness credibility and the integrity of the state's case. This is like, it's now turning into Courtney Clenny part 2. We're going to cover her today as well. But like, if you weren't here for the last update on her, her defense team is basically getting the state assistant or whatever district attorney's office thrown out because they leaked information or they passed around information or accessed information that they weren't entitled to. And this is what I'm basically kind of seeing here. Like, and that's actually might go through on the Courtney Clenny case. So if they really do think someone on the prosecution team leaked something, they're going to have to get rid of the whole prosecution staff, unless everybody's going to go under like a deposition and then like testify or something. I don't know how that works. The apparent leak is not an egregious violation of the court's non-dissemination order. It enabled Dateline to gild rampant speculation with the veneer of credibility. When purportedly exclusive information surfaces through a media broadcast shortly before trial, particularly information attributed to unnamed sources with access to the investigation, it carries a high-end aura of credibility and secrecy that can deeply influence public perception. Unlike official disclosures, which are typically accompanied by context and procedural safeguards, leaks framed as exclusives are perceived as uncensored truths that the public was not meant to see. This insider framing enhances the material's persuasive power, suggesting that it is both authentic and revealing of the case's hidden realities. And Taylor was the actual source of the leak. Hey, Adrian. I have not. I know. Somebody said that to me earlier. They were like, really? You of all people hasn't watched it? I'm going to watch it tonight or tomorrow. And I'm sure we'll probably have to come back here and talk about it. The episode includes things such as repeated speculative assertions regarding the assailant's motives, including unfounded allegations of SCX motivation, dramatic reenactments and animations depicting the alleged crime created by the show's producers, emotional interviews with individuals connected to the alleged victims, accompanied by evocative music, photos, and videos designed to elicit strong emotional responses. The broadcast repeatedly bolstered its speculative claims through the use of so-called expert commentary, including individuals identified as law enforcement professionals and academics. These commentators were permitted to make sweeping assertions about the defendant's alleged motives, psychological state, and the personal history, none of which are grounded in evidence before the court, while the program repeatedly emphasized their training, research, and years of experience to lend undue credibility to their conjecture. This type of testimonial mimicry improperly mirrors expert witness testimony in a trial setting without the safeguard of cross-examination or evidentiary standards, effectively presenting the public with a one-sided, unvetted narrative that shapes jurors' perceptions before any admissible evidence has been presented. While the program occasionally inserts disclaimers such as "we don't know what happened," these brief caveats do little to mitigate the cumulative impact of an extended narrative constructed through selective imagery, emotionally charged reenactments, and detailed speculative descriptions of the crime. When viewers are presented with a cohesive, visually reinforced sequence of events, specifically when paired with commentary from individuals styled as experts. The overall presentation fosters a sense of authenticity and truthfulness that is difficult for viewers to disregard. An occasional passing verbal disclaimer functions more as a legal formality than a meaningful check on prejudicial perception, and most viewers will leave with the impression that they have seen a reliable reconstruction of events. What? The Dateline special, which aired just weeks before the trial date, will not even be the last pre-trial media quote-unquote bombshell. Best-selling crime author James Patterson. Oh, I just said that. James Patterson has a written book about the murders titled The Idaho Four, an American Tragedy, scheduled for release on July 14th, 2025, just 16 days before jury selection is slated to begin. I can't wait. I can't wait. I can't wait. I can't wait. Hey, Torta Pounder. Wow. Wow, wow, wow. The blurb, I'm such a book nerd. The blurb for the book describes Mr. Kohberger as a brilliant grad student, loner, and apparent incel, and explicitly tells the reader, now you are the jury. The evidence is in. Oof. The publisher boasts of unmatched access to the investigation, including interviews with local law enforcement. This suggests that the apparent Dateline leak was not the only violation of this court's non-dissemination order. Ooh, not James Patterson having come up to the stand. They're going to have to figure out where he got his info from. The Sixth and Fourth Amendments guarantee the right to a fair trial by an impartial jury. A continuance is necessary to fully investigate the leaks and tend to mitigate the prejudicial effects of such inflammatory pretrial publicity occurring so close to the current trial date. In Shepard versus Maxwell, the Supreme Court held that the defendant was denied a fair trial due to massive, pervasive, and prejudicial publicity that the trial court failed to mitigate. The court emphasized the trial judge's responsibility to ensure that the defendant receives a fair trial free from influence of prejudicial media coverage. The court explicitly noted that a continuance may be required to protect the defendant's rights. The Supreme Court has likewise recognized that the passage of time can significantly reduce the taint of media exposure, holding in Patton versus Yount that even in a case involving extensive coverage of a confession, the delay between media saturation and trial reduces its prejudicial impact. The court has recognized that while pretrial publicity, even pervasive adverse publicity, does not inevitably lead to an unfair trial, the trial judge has a major responsibility. The measures a judge takes or fails to mitigate the effects of pretrial publicity may well determine whether the defendant receives a trial consistent with the requirements of due process. The timing of the trial is a key factor in ensuring juror impartiality, as emotional intensity and memory of prejudicial material tend to fade over time. Social science research supports this position. A comprehensive meta-analysis found that pretrial publicity significantly increases the likelihood of conviction, but that the effect is diminished where there is temporal delay between media exposure and trial. In sum, the 2-hour Dateline episode is uniquely prejudicial in both tone and content. It constructs a speculative narrative around motive and guilt, features emotionally manipulative production elements, and amplifies unsupported theories through self-styled expert commentary, all timed to air just weeks before trial when jury impressions are most vulnerable and voir dire, least equipped to neutralize deep-seated bias. The forthcoming book by James Patterson, which will arrive in the hands of potential jurors just 2 weeks before the voir dire begins, promises to set off a new round of inflammatory negative coverage and deepen the pervasive bias against Mr. Kohberger on the eve of trial. The court has already acknowledged that the Dateline special exposes a likely violation of non-dissemination order, and Mr. Patterson's purported purported unmatched access to sources, including law enforcement, suggests that multiple unauthorized disclosures have occurred. Depending on the results of the investigation into the leaks, a continuance may be adequate. Once the sources of the leaks are identified and the full extent of the misconduct revealed, the violations can warrant remedies more serious than delay. At the very least, however, a continuance is essential to allow the extremely prejudicial impact to partially subside and to give the court and the defense time to fully investigate and address the scope of the violations. Only then can the conditions necessary for selecting an impartial jury and ensuring a fair trial under the Sixth Amendment and 14th Amendments be meaningfully restored. Reversal is more likely than not in any case resulting in a death sentence. Statistically, almost 2/3 of death penalty cases are eventually overturned due to errors, often many years or decades after the initial conviction. A frequent cause is reversal on ineffectiveness grounds due to the lack of an exhaustive investigation and complete presentation to the sentencers. Hundreds of cases could serve as examples, but for brevity, the following are examples from the United States Supreme Court and the Ninth Circuit courts that will have jurisdiction over the review of this case in the event of a death sentence. Andrus versus Texas. Counsel provided deficient performance by overlooking vast tranches of mitigating evidence, including the fact that the client suffered very pronounced trauma and suffered from affective psychosis by the time he was 11 years old, and by failing to adequately investigate and rebut the state's case in aggravation, remanded to lower court to address prong of Strickland. Porter versus McCollum, another case, Rumpilla versus Beard. Even when a capital defendant and his family members have said no mitigating evidence is available, his lawyer is bound to conduct a social history investigation and adequately follows up on red flags, hiring three well-reputed mental health experts without conducting the proper life investigation still constituted ineffective assistance of counsel. Wiggins versus Smith. Basically, they name off all these cases. Stankiewicz versus Wong. Liberton versus Ryan. Counsel failed to adequately investigate mitigating evidence. Lambright versus Shiro. Again, failed to adequately investigate and present in sentencing the mitigating evidence defendant's trauma from serving in Vietnam. Pearson versus Woodford. Hovey versus Ayer. So these are all cases that have been overturned for the reason that they're asking to have an extended trial, a trial delay. Mr. Kohberger deserves a fair trial from the outset to prevent an arbitrary or wrongful conviction and potential death sentence. These cases underscore the critical importance of a thorough investigation before trial. This diligence is essential to avoid the costly and time-consuming process of reversing a conviction and death sentence years or even decades later. A continuance is reasonable and necessary under the circumstances. While there is no mechanical test for determining whether a continuance should be granted, a trial court cannot deny a continuance based on a myopic insistence upon expeditiousness in the face of a justifiable request for delay. In determining whether a denial of a continuance request resulted in the violation of due process, the reviewing court looks to the circumstances of the case, particularly the reasons presented to the trial judge at the time of the request was denied. This request is not made lightly. Defense counsel has worked around the clock actively preparing for trial since appointment to this case, followed all motions in a timely manner, complied with expert disclosure deadlines, and has expected to proceed on schedule. However, it has become clear that without additional time, the defense cannot complete review of necessary discovery, meaningfully respond to all of state's amended expert disclosures, and incorporate the information into effective defense, and finish critical sentencing phase investigations. While prompt administration of justice is important to both the state and Mr. Kohberger, the constitutional guarantee of a fair trial outweighs modest delay. And because the majority of cases ending in death penalty are later overturned for error, the public interest lies in ensuring a fair trial in the first instance. A continuance will ensure that Mr. Kohberger's fundamental constitutional rights are honored and that any verdict rendered rests on a fair and complete presentation of the facts, not on forced haste. Dated May 20th, 2025. Ann Taylor. We did it. We got through it. I can't believe it. I can't believe it. I think it might happen. I think the trial might be delayed. What do you guys think? Let me know. Yeah, we did. We did. We made it. That was a very good document. Yay. Yes, we have another live, 2 more lives scheduled right after this. So I'm curious to find out what happens. I can't wait for the James Patterson book. I can't wait to watch that Dateline episode and maybe do like a live on it, like a vertical on it, like a Millie After Dark, and talk about it. I'm shook. I'm shook too. I'm shook. Will Bryan Kohberger's trial get delayed? How sad. That's so sad. That really is so sad. Like all this information is coming out and the families just have to deal with it, and it just sucks. But justice for Idaho 4. I'm curious to see what happens. I don't even know when the next court date is set, but we are still watching the old, not the old, but the last hearing. I have not reviewed that on my channel, so we might get to that today. I haven't planned on another Bryan Kohberger and then Karen Reed. So make sure you guys hit the like button and subscribe. I will see you guys on the next one. Let me know what you guys think about the Bryan Kohberger case. And thank you for being here. But I'll catch you on the next one shortly. So keep your eyes out for the next live. Bye.